Hi everyone, I'm Chip Muller, the founder of Muller Law, and I want to talk to you today about an important rule in employment law, and that's called the at-will employment rule. I talk to employees and potential clients about this a lot, and so I want you to really get to know this rule. It applies in Rhode Island, Massachusetts, Connecticut, and really most states in the United States. And it's a powerful rule, and here's what it says, that employers basically have the freedom to fire, demote, terminate employees for almost any reason at almost any time. It's a powerful rule because it's going to be counter to what you think is right in most situations. Let me give you an example. Let's say that an employer wants to terminate an employee for a really what you would call an irrational or stupid reason. Let's say you have purple hair. Let's say the employer doesn't like the fact that you have purple hair, but you have no contact with the general public or clients. It makes no sense that this employer doesn't like purple hair, and it has nothing to do with your job performance, but you get terminated because you have purple hair. Perfectly acceptable under the at-will employment rule. Another example, let's say that the employer makes a decision based on false information. An error, a mistake. Let's say that an employee, a coworker that doesn't like you, gives false information to your supervisor that you made a mistake that you actually did not make. So long as it doesn't fall into one of the exceptions to the at-will employment rule, and I'll cover those later, it's perfectly acceptable under the at-will employment rule for an employer to terminate an employee for a false or incorrect reason or a mistaken reason. A third type of way that the at-will employment rule can affect you is in sort of what I would call disloyal or mean-spirited disregard for your value to the company. A lot of employees that have worked for a company for a long period of time and or have devoted their whole life to the employer feel very offended sometimes when an employer makes a decision of demotion or termination in apparent disregard for all those years of service and dedication to the company. Under the at-will employment rule, it doesn't matter how hard you worked for the company. It doesn't matter how well you did for the company. It doesn't matter how loyal you were for the company. All of that really is not a factor. The courts are going to give the employer great latitude to an employee, to the employer under the at-will employment rule. Now, there are some important exceptions, very important exceptions to the at-will employment rule, which I want to cover. I'm going to do videos on each one of these in greater detail, so you should check out those videos. But I want to give you a quick overview of those exceptions now because they're important. Number one is the state and federal governments have passed statutes that override the at-will employment rule, and the most common and well-known of these are the discrimination and retaliation statutes. All states in the Rhode Island, Massachusetts, and Connecticut region have statutes prohibiting discrimination and retaliation in the workplace and harassment of certain kinds in the workplace. So if you have been the victim of discrimination, retaliation, or harassment in the workplace that is covered under those statutes, the at-will employment rule does not apply, and the employer cannot depend on that rule generally to get out of its liability under those anti-discrimination, anti-retaliation, anti-harassment statutes. There's also whistleblower protection statutes. There's statutes protecting requiring employers to provide certain overtime and pay benefits, all kinds of statutes, worker health, workplace health statutes under the Occupational Safety Health Administration Act, all kinds of statutes that are exceptions and important exceptions to the at-will employment rule, and you really need the consultation with an attorney to determine if one of those exceptions applies. Another important exception to the at-will employment rule is an individual employment contract. If you have entered into an official employment contract for a number of months or years of employment with that employer, then the employer, probably under the terms of the contract, or perhaps under the terms of the contract, if it's worded correctly in your favor, cannot terminate you for any reason at any time because of that contract. So the at-will employment rule will probably not apply in that situation either. Another important exception to the at-will employment rule is the collective bargaining agreement. If you're a member of a union and that union has entered into a contract on behalf of its union members with the employer, the at-will employment rule does not apply. The terms of the collective bargaining agreement do apply, and you need to talk to your union steward, your union representative, or an attorney about how that collective bargaining agreement applies to your particular situation. So the takeaways here are that, number one, the at-will employment rule applies to the vast majority, I would say, of all terminations and demotions and cuts in pay, etc. And it's a difficult concept for a fired employee or a demoted employee to get their head and heart around, because it can seem really harsh. It can seem really irrational at that moment of need in your life. But it is a powerful rule in the court system. And however, there are many important and equally powerful exceptions to the at-will employment rule. You need to consult with a valuable, experienced attorney to determine if one of those exceptions applies to your particular case. If you have any questions, please contact Muller Law or another outstanding employment law attorney to see how these laws and these rules affect your particular situation. Thanks.